It's time for the real crimes of Kurri Kurri. In this AVO episode, we look at a case where the magistrate decided to make an AVO, an apprehended violence order. Most AVOs are applied for by the police. However, on this day in April 2025 at Kurri Kurri Local Court, the police had decided to only bring a charge without an AVO. There's no background as to their decision. Sometimes the police don't seek an AVO in violent type cases. The law, under some circumstances, enables the magistrate to issue an AVO regardless of what the police do. And on this day, after the magistrate reads the court papers, they decide an AVO should be made. The story starts as a civil matter just outside of Kurri. There's two guys. They were in a business relationship in the same industry. Sorry, I'm not going to describe what work they do because that might identify them. Kurri is a small town. Anyways, it's a civil matter because it's alleged one guy owes the other guy money. In March 2025, the court is told the guy owed money, goes around to the other guy's home just outside of Kurri. In a rage, he terrorises the other guy in his home, demands money and jumps on top of his car. That's when the civil matter becomes a criminal matter. Enter the police and the New South Wales Local Court. In April, the middle-aged defendant shows up at Kurri Kurri Local Court and via his solicitor accepts that he could have dealt with the situation differently. The court is told he does not have a great criminal history. Classic legal speak, not great criminal history. Anyways, the magistrate has a bit to say, such as discussion about taking the law into your own hands. The guy's convicted of both offences, which are actually never said out loud. I assume the charges might be like intimidation or damage type offences. He is sentenced to a community corrections order for 12 months. That includes a place restriction that is consistent with the AVO conditions. The rest of the time is spent on the magistrate making the AVO. Without information from the police, the magistrate tasks people to find out where the soon-to-be pin-op lives. Pin-op means person in need of protection. And in this case, the pin-op is the guy that allegedly owes the money and had his car jumped on. Anyways, they work out his address and birthday, which is needed to make the order. The AVO has the standard condition, must not assault and intimidate, etc. Plus no contact and cannot go within 100 metres of the pin-op's home. Small issue now is the pin-op / victim and the now convicted defendant may cross paths if they work on the same job in the industry that they work in. So the magistrate amends the AVO to allow contact via a solicitor or incidental contact at work. So sometimes the magistrate may seek an AVO to be made regardless of if the police make an application or not.